Welcome to the Rozanne On Demand CFPB video series, featuring Ontario System's Chief Compliance Officer, Rozanne Anderson. Widely recognized as a leading authority on collection-related compliance, Rozanne leads Ontario System's corporate efforts in response to the CFPB's launch of compliance examinations in the ARM industry. In this ongoing video series, Rozanne takes a deeper dive into the entire regulation, helping you make sense of the new rule and what it means for your agency. Before we get started, please take a moment to review our legal disclaimer. The information shared today is not legal advice. Please consult with your own independent legal counsel before making any business decisions regarding the use of this information.
Welcome to the second episode in our CFPB video series. Today I'll walk you through what you need to know with regard to limited content message, the review of Zortman, the review of the FODI message, and ringless voicemail message issues and solutions. For your reference, I will be covering part 1006 of the new rule for debt collection, Regulation F, Subpart A, 1006.2 definitions. So let's take a look at this limited content message. The CFPB did introduce new terms for us to appreciate. And one such new term is the limited content message. So what is that kind of a message? The reason it's called a limited content message is for obvious reasons. It's because the content is absolutely limited by law. And what the CFPB means by that is this. A limited content message is a voicemail or a voice drop, such as a ringless voicemail, for a consumer, not a text or an email or a letter, and not left for a person, left for a consumer. So I'm going to review that. It is a voicemail or a voice drop message, including a ringless voicemail for a consumer, and it does not include a text message, it does not include email, and it does not include a letter. If you leave a limited content message for a third party, someone who is not the consumer as defined under the Regulation F and the Fair Debt Collection Practices Act, you will not receive the protections afforded those who leave a limited content message. So what does that mean? It means the CFPB went out of its way, in my opinion, to provide the debt collection industry with an answer to its long-standing question. How do we leave a voicemail message with a consumer? For those of you who have been in the industry since the late 90s, you will be aware of a case where the plaintiff was FODI. The last name of the plaintiff was FODI. And FODI sued a very, very large debt collection agency, Mr. FODI did, and argued that the voicemail message that the agency left on Mr. FODI's voicemail machine violated the Fair Debt Collection Practices Act. And the basis for Mr. FODI's claim was that the debt collection agency left all sorts of information about the debt. They identified themselves as a debt collector. They even encouraged the person to call back, to return calls to the collection agency. And Mr. FODI said, that can't possibly comply with the Fair Debt Collection Practices Act because you may have inadvertently, Mr. Agency, disclose the existence of this debt to a third party. Someone could have been listening to this voicemail message who had access to it. And therefore, you cannot leave a voicemail message with that kind of information about it, meaning you cannot leave a voicemail message on my answering machine with all sorts of information about the fact that this is a communication in connection with a debt and that you are a debt collector. The debt collectors are all saying, how can that be wrong? The FDCP also states that when communicating with a consumer, you must meaningfully identify yourself as a debt collector. So what is it? When we leave a voicemail, do we provide all the information that we would use to meaningfully identify ourselves as debt collectors? Or, as Mr. FODI believes, we leave nothing to suggest that we're a debt collector. Which is it? And the court said, leaving all that information on an answering machine message does violate the FDCPA because of the potential for that message to reveal the existence of the debt to a third party, which is absolutely prohibited under the FDCPA. So debt collectors stepped back and they thought, I'm not leaving any more voicemail messages. Others said, I'm still leaving messages and we'll just take it up in the legal jurisdiction that we're in and see what happens. And that's exactly what happened. Voicemail message cases popped up all over the United States. And then one day, a debt collection agency in Minnesota, J.C. Christensen and Associates, had a very good idea. And it stepped back from the Foti case and it said, what was wrong with the Foti message? Let's just think about it. The court in that case said, this might, if we leave this kind of message, this might reveal the debt to a third party and they'll know, oh, Mr. Foti owes money to a debt collector. So let's do this. Let's not leave the name Foti, i.e. the name of the consumer in the message at all. Let's just leave a message such as, this is a message from Bob Anderson, a debt collector. Please call me back at ABC Debt Collection Agency. This is a communication from a debt collector and all information obtained will be used for that purpose. Again, please call us back at the following number. The idea in that message was that the debt collector fully identified itself in a meaningful way under the FDCPA and made clear that it was a call from a debt collector, but it did not associate the message with a person. This is called the Zortman message, and it was a case brought by a woman who said the same thing as Foti. You can't leave that message. Foti said, you cannot leave all that information because someone listening to my voicemail message may think, oh my heavens, so Mrs. Zortman owes a debt to a debt collector. The court all the way up to the 8th Circuit said, we don't buy it. We don't see it that way. If the debt collection agency does not associate the voicemail message with a particular person, could have been a wrong number. Anyone listening to it may think, well, I don't know who that's for. It can't possibly be for Mrs. Zortman. Can't possibly be for Mrs. Anderson. It's because there's no consumer's name associated with the message. And the industry went on for a number of years. At the same time, literally begging the CFPB to bring clarification to the issue. And so they did. It is now permitted under the law for debt collectors to leave a limited content message and enjoy the protections of a safe harbor, meaning a defense that they have not violated the FDCPA if they leave the following message. This is Robin Smith calling from ABC Inc. Please contact me or Jim Johnson at, and then they leave the phone number of the debt collection agency. What this limited content message is in essence saying, you can leave the name of the debt collector, the actual person calling. You can actually leave the name of the debt collection agency. You cannot leave the name of the consumer in the message, and you can ask the person to call you back or an associate within your agency at a certain number. So again, the limited content message affords a debt collector who uses this message as a voicemail or a ringless voicemail certain protections. If they simply identify themselves, they do not include a Miranda disclosure, they identify the name of the agency, and they tell the consumer who to contact and at what number. The CFPB went on to say, and to be a little nicer, kinder, gentler, I guess, organization to the industry, we will allow you to include some optional information. And that optional information, which you may include in a limited content message, is a salutation, such as hello, the date of the message, the time of the message, suggested dates and times for the consumer to reply, a statement that if the consumer does reply, they may actually speak to any one of the company's representatives or associates. It need not be Jim as given in the example. So debt collectors are going to be able to enjoy the protections afforded them by Regulation F if they use the limited content message. But many debt collectors ask the following question: does that mean I cannot leave a Foti or Zortman message? And the answer is no. There is no law saying if you leave a voicemail message, debt collector, you have to leave the limited content message. It simply is a statement that if you use the limited content message, you will enjoy protections against a claim that you inadvertently violated the FDCPA by disclosing the debt to a third party. Thank you for tuning in to episode 2. I hope you now have a better understanding of today's topics, and I look forward to seeing you next week. Thank you.
Please join us next week for episode 3, where Rozanne will be focusing on the special definition of consumer, communications with a consumer, and exceptions. Also, be sure to visit the Ontario Systems website, where you can subscribe to receive exclusive updates and be notified as soon as the CFPB episodes are published.